Good morning, everyone. Welcome to the RCI GDAS webinar titled Legal Issues, Empowering Service Providers on Dementia-Related Family Issues. It will be presented today by David McGuffey, Certified Elder Law Attorney. Before we get started, let's cover a few conference details. If you have a question during the conference, we ask that you type in the question. All questions will be answered at the end of the conference. Also, if you are at your own computer station, a post-test survey will pop up at the end of the webinar. There will be 10 questions about the webinar and personal information questions such as name and email address that will enable me to send you your certificate. If you are not at your own computer, copy down the link that is posted on the last slide of this presentation. Use the link at your own computer to complete the post-test. Certificates will be sent out within 1 week after closing of the test. Please complete the post-test before November the 20th to receive your certificate. We are now ready to begin. Good morning, Mr. McGuffey.
Good morning. I am happy to be here with you, and we will be discussing ways to work with family members where there are dementia-related issues. One of the first things that we have to think about as we're working with families, typically they're going to be in crisis. They're not thinking clearly. You're going to need to have more understanding than you would. And if you've been working in this field, obviously you know, but you're going to need to have a high level of understanding. Most people are not used to surrogate decision making. They're not used to the process that they have to go through. Typically, we will have family disputes. We'll have multiple children who are fighting for control, or we will have someone who is being paternalistic and trying to exert control over a person who can still make some decisions. So the first thing that you're going to want to do is be mindful of the crisis that the family is going through. We're going to start with an example. Lois was diagnosed with dementia in 2012. She's in your healthcare office. Lois's daughter, Ginger, came with her. Who should you talk to? And that's something that comes up regularly because many people will presume that an individual who has a diagnosis of dementia is no longer part of the decision-making process, but that's not true. The fundamentals are that we can give someone consent to talk for us, but the patient is always presumed to be the captain of their own ship. Any adult may give consent for himself or herself, orally or otherwise, to any surgical or medical treatment, which is not prohibited by law. They can also do this by giving power to someone else to make decisions for them, but the adult, the patient, is always in charge of their own health care. Most of these slides will have citations on them. Since you are professionals listening to this program, I've tried to give you citations so that you can go back and look at the original source material if you so choose. So the default rule is that every adult is presumed to be endowed with normal faculties, both mental and physical. And the question that you have to decide is whether that default rule is appropriate. You always start by trying to talk with the patient and involve the patient as much as they can be involved in the decision-making process. So until you reach the point where a patient is adjudicated as incapacitated, you're going to want to try to work with them. You're going to want to talk to the patient. Now, does that mean that you can't talk to Lois? Well, no. Or to Ginger. If Lois says that you can, then obviously you can. Many adults are going to bring a family member with them as much as anything to serve as a record keeper, to remember conversations that took place. but the default rule requires that you start your discussion with Lois. There's no presumption of diminished capacity. The law never presumes that. And talking to Lois promotes autonomy and dignity, and it gives you a chance to do an assessment. Remember that, you can't know with certainty that Lois is unable to participate in her healthcare decision-making process until you've assessed her ability to do it. So the starting point is always talking with a patient. You need to determine whether Lois understands the nature and effect of the decision at hand. One of the things you're going to want to do is determine whether, if there's any confusion right now, is it delirium or dementia? Just because Lois has a diagnosis of dementia doesn't mean that her current state of confusion, if she's confused, is the result of progressed dementia. It may be that Lois has some medication error, or that she hasn't been taking her medications appropriately, or maybe she's depressed, or something else is going on. So if she's acting confused, then talking with her and going through your regular process of testing would let you determine whether there's some overlaying delirium on top of the dementia. So what's the cause, and how long has this been going on? When you're trying to figure out whether someone has capacity, there are a number of tools out there. I've given you a few on this slide. These booklets are all available for download in PDF format at the APA website. There is a handbook for psychologists, a handbook for lawyers, a handbook for judges, but these are all written, or they're co-written by the APA, and they're going to give you a number of tools that you can use in determining whether someone has capacity. There are similar tools that can be used in determining capacity on the American Bar website, and then you would have your normal tools that you use in your healthcare practice, your mini mental exam, and other tools of that sort. So even if Lois appears to have diminished capacity, the law recognizes that capacity is a fluid concept. Lois might be able to make some decisions, but not others. I was in a guardianship hearing last Monday. It was a contested guardianship hearing, and one of the things that the courts now look at is not just whether we need a guardianship, but if we do, to what extent should it be imposed? So even in situations where the law proactively takes power from Lois or some other individual, we're still looking to give Lois as much input and as much control over her own life as she can possibly have. We're no longer in a state where we look at what we used to call a plenary or a full guardianship. Now, even in the guardianship context, we're trying to make sure that we only take those protective steps that are necessary. So with that in mind, in this context, Lois may be able to make some decisions, but not others. And what does that tell us? Again, back to our original example, if Ginger's in the room, there may be some things that you would want to talk with Ginger about, but you're still going to want to talk with Lois, and you're going to want to involve her in her own decision-making process as much as possible. The medical decision-making process is rooted in the concept of informed consent. Informed consent requires that someone's consent be competent, that it be voluntary, and that it be informed. So even if it takes a little longer, as long as Lois can make decisions, and if she wants to participate in her decision-making process, we have to give her enough time and enough information so that she can make these informed calls. And if Lois defers, if Lois says, I brought my daughter here, tell her what to do, I'm going to defer to her and let her make decisions. Well, that means you can talk to Ginger, and that means that it's appropriate to focus on Ginger, but the reason why is because Lois has said do that. An individual always has the right to appoint a decision maker if they so choose. Lois resides in an assisted living facility. What if Ginger does not get along with her siblings and wants to keep them from visiting? I mean, that comes up regularly. It seems that anytime there are two or more siblings gathered in the same room, the chances of an argument are rather high. Some families do get along, and we're very happy for those families, but many of them don't. And it's not uncommon for siblings to play capture the flag with mom, and that puts the healthcare provider in a precarious situation. What does the healthcare provider do? How do you manage in that situation? The presumption, again, is that Lois has capacity until a probate judge says otherwise. So Lois, not Ginger, should be making her own decisions regarding visitation for as long as Lois has the ability to do it. The elder abuse, the National Elder Abuse Incidence Study recognizes a number of different forms of elder abuse, and one of them is isolation. And if Ginger is trying to crush Lois's ability to make decisions and spend time with her sibling or her other children, then that could be a form of isolation. So we want to keep that from happening. We want to continue to let Lois make her own decisions for as long as she can. But what if Lois cannot make decisions? And you're there as a healthcare provider, and you're trying to figure out, who do I listen to? Well, that's where we start getting into the way the law works to appoint someone as a decision maker. Who's in charge? We all remember, at least those of you who are at least as old as I am, I feel like I'm getting older every day. I remember when Al Haig stepped up to the plate and told the country he was in charge, and he was quickly removed from power and informed that that was not the case. We will typically have situations where confusion comes up because the wrong person or a person without power is trying to make decisions, and that can become a problem. So you need to know what the rules are. If Lois did her planning, then the initial inquiry is whether Lois appointed a surrogate decision maker. That can be known as a health agent, can be known as a health surrogate. In Georgia, you're going to want to look for a document called a Healthcare Advance Directive. Those are available for free at every law school's website in Georgia. They're going to be available for free at many government websites, and there are generally stacks of them at most healthcare facilities. One reason why there are stacks of them, the federal statute requires that facilities which accept Medicare or Medicaid provide people with guidance regarding their ability to appoint a health surrogate or to make end-of-life choices. And the easiest way to provide that guidance is usually to hand someone a copy of the document along with its instructions and invite someone to make decisions. The result is you're going to have all these documents laying around. So you will have situations where someone either has appointed a healthcare decision maker or has the ability to do so now if they still have legal capacity. Now, there may be some older documents out there. Georgia law changed in 2007. Effective July 1, 2007, we used the Healthcare Advance Directive. Prior to that time, we used different documents in Georgia. Those documents are still valid. So if someone has an old health care power of attorney or an old living will, it is still valid. But since July 1, 2007, we should be looking for an advanced directive for health care. These documents are rooted in the law of agency. And I'm trying to be very basic here, but I also want to give you an idea of what we're talking about. The law allows you to appoint someone to deal with third parties. You frequently will do that with a power of attorney. You might do that with a healthcare advance directive. Many people think about these situations in terms of employer-employee. That's probably the easiest way to put your mind around this concept if you've never dealt with these documents. An employee goes out and does things for their employer. When they do that, they are an agent for their employer. They're acting for that employer. They might run errands for them. That is essentially what someone is doing when they've been appointed as a healthcare decision maker. And one thing that I run into all the time is the misconceived notion that the patient has given away their rights. When you appoint someone as your agent, you're really asking someone to help you. And you always have, as long as you have capacity, you always have the right to do what Donald Trump tells us to do in his Celebrity Apprentice show. You can tell your agent that you're fired if they are no longer following your wishes. So I encourage everyone that I work with to execute these documents. And if your agent is not doing your bidding, then I encourage people to fire them and appoint someone who is doing their bidding. One of the purposes of appointing an agent is to limit controversy. That's one of the things that bogs down decision-making in your office. You know, who do we listen to? Who's in charge? Are we back in the Al Haig situation where we don't really know who's in charge? We've got someone who is loud and boisterous who's trying to take over but without any legal power to do so. So we want to limit controversy. We are also trying to create a decision-making structure so that we don't end up going to the Supreme Court several times like we did with Terry Schiavo. One of the things that people don't remember, or many people don't know about the Terry Schiavo decision, there actually was a person who was appointed to make decisions, but in that situation we had an absence of direction, so that we had the parents of Terry claiming that the husband was abusing his authority. When we do these appointments, it's always good if we can go the next step and try to flesh out what the patient wanted. So in that leads to the next point. This is created by the patient and is designed to serve the patient's goals and values. If you have access to documents like critical conditions or 5 wishes, they will include a health values worksheet. Those are not just fluff documents. If Terry Schiavo had created or had filled out a health values worksheet, we probably would have saved several years of litigation, hundreds of thousands of dollars in legal fees, and who knows how much time and heartache on the part of the providers who were trying to figure out what to do. So one of the provider's goals is to identify the decision maker, to gain authority to help the patient, and then to build a patient-centered team. We hear all the time about, or these days, about being patient-centered. Part of being patient-centered is looking for the patient's goals. That's inherent in the concept of informed consent. We're not simply doing things to the patient. We're doing things for the patient consistent with the patient's goals. Sometimes in the long-term care setting or when we're working with someone who has dementia, that we will be at an end-of-life situation, and one of the goals may be to allow the patient to have a natural death. I spent a good bit of time with a doctor who, not that long ago. He was a medical director with a hospice entity, and one of the things we were talking about was quality of life versus quantity of life. He was telling me that one of the traps that providers sometimes fall into is this notion that we're out there trying to defeat death and that we should do everything that we can to defeat death. That may not be the patient's goal. The patient's goal may be to have a high quality of life for as long as possible, but then to have a natural death. And that gets back to learning what the patient wants and then building a patient-centered team to accomplish the patient's goals. If the patient, in our example Lois, can no longer make decisions, then the next person in line, the person the provider should be looking to, is the one who is authorized by the patient to make decisions. And that will be, in Georgia, that will be in an advance directive. Or the older documents, the health care power of attorney. The Georgia Code gives us a hierarchy for who makes decisions, and it's always going to be the patient followed by the person appointed in the advance directive. Typically, this will not be the financial document. Sometimes people will be confused. They will have a financial power of attorney. Those can also be called general powers of attorney or durable powers of attorney. Most of those documents, if you look at them, will be limited to finances, and they will probably not appoint a healthcare decision maker. Some of the older documents tried to combine both the healthcare and the financial decision making, so it is possible that you will run into older documents that attempt to appoint a health decision maker, and they may accomplish that goal. One of the things that you need to keep in mind, Georgia law does not require that we use a particular form. You can deviate from the standard form and customize it. And the law indicates that those customized forms are still valid as long as they include the elements, the required elements in the statute. So you can't presume that a funny-looking form won't do the job. Many of them will if they're prepared by an attorney. The advance directive for health care, the statute is in the official code of Georgia, annotated section 31-32-1, etc. As I said earlier, it was effective July 1, 2007, and it replaced the old forms. The purpose of it was to simplify the process of appointing a surrogate, to make it easier for people to take care of these issues. I'm not certain that we accomplished that. I'm not certain that the legislature made it easier, but that was the goal. One of the reasons why it was done was to combine in one place the appointment of a healthcare surrogate and the selection of end-of-life decisions that you used to see in a living will. Many people would do one but not the other in the old documents. The document operates in one of two ways. If you appoint a health surrogate, then that health surrogate would have the ability to make decisions, and it's going to operate primarily the way the old healthcare power of attorney did. If it fails to appoint a surrogate, then it's going to operate the way the old living will form did, and it's going to give you the end-of-life decisions. It has 4 parts. Part 1 designates a healthcare agent. Part 2 includes treatment preferences. Now, these predominantly are structured, at least under the statutory form, they're structured as end-of-life treatment preferences, but there is a place inside the form where we can include additional treatment preferences which may or may not be end-of-life types of decisions. I had someone in my office last week who is a Jehovah's Witness, and that individual has made certain statements regarding treatments that they do not want, and we can include those treatment preferences in Part 2 of the Advanced Directive for Healthcare. Part 3 allows us to nominate a guardian. If you get to the point where you need a guardian, then the law presumes that the person nominated by the ward patient is the person who should be appointed. That can be rebutted if there's evidence of abuse or if there is something else going on that would cause the court to skip that person, but we're always supposed to look initially at the individual appointed or nominated by the proposed ward, and that can be done in the Advanced Directive for Healthcare. Part 4 is where we execute these documents. When we're looking at an advanced directive, a proper form is a written document. It's voluntarily executed by the patient. Some improper forms obviously would not be in writing, would not be voluntary, would be executed by someone other than the patient. The exception would be if, and the law does provide for this, if the document is signed by some other person in the patient's presence and at the patient's express direction. If you are trying to visualize when this might occur, you might have someone who has a paralysis or who has some kind of inability to use their arms or hands, and in that situation, if the patient can give another individual express direction, then that individual can execute it for the patient in their presence. Going through the document, Part 1 is going to appoint someone to act for the patient, to make health decisions when the patient is unable or chooses not to make decisions. That gets back to what I was talking about with Lois and Ginger. Lois has the right to make her own decisions, but she can choose to defer to Ginger, and many patients with dementia will do that. So in that situation, if Ginger is the health agent, then even though Lois is in the room, she may have deferred to Ginger. Things to remember that the physician or provider cannot serve as the agent. That is protective of you. Many patients believe that their doctor is one step removed from God, and there are good reasons for that. We want people to trust their doctors. We like having smart healthcare providers. We all want to believe that our healthcare provider is very knowledgeable about what's going on with our bodies and our minds, and is helping us make the right decisions. But that gets back to the idea of informed consent. They're helping us make the right decisions. They're not making the decision for us. And that's why the provider can't be directly involved. If they were the one making decisions, then there would not be any informed consent by the patient. Part 2, when we're talking about treatment preferences, a healthcare agent shall not have authority to make a particular healthcare decision different from or contrary to the patient's decision if the patient is able to understand the general nature of the healthcare procedure. Remember, the patient is always in charge. The healthcare agent is not the boss of you. You don't have the ability to tell mom what to do simply because mom has appointed you to help her. I run into that far more frequently than I would like to. People will frequently tell me that they have power over someone, which immediately tells me that they don't understand the documents they're working with. If you think you have power over someone instead of power to help someone, then you don't understand what you're supposed to be doing. The other thing that I want to point out, one of the reasons why we want those health values worksheets, we don't want to run into the Terry Schiavo situation where we have a decision maker who is allegedly making decisions contrary from the patient's values and goals. If we have a health values worksheet, then we're going to have evidence that the healthcare decision maker is doing the right thing. Or if they're not doing the right thing, we'll have evidence that direction as well. And it helps us as we're trying to figure out whether someone is doing this the right way. The provider response, a health decision made by a healthcare agent in accordance with the terms of an advance directive shall be complied with. Remember, it's not about you. You're there to help. The same way as an attorney, it's not about me. My job as an attorney is to provide effective representation for my clients consistent with my client's goals. The legal ethics rules require that I have a client who is able to guide and direct the scope of the representation. So I make decisions in a manner that is very similar to the way you as a provider make decisions. It is an informed consent process where I'm telling my clients what their options are, presumably what the different risks are, and then the client makes the decision. In your case, it's the patient making the decision. So we want to, the law provides that the decisions will be complied with. And again, this gets back to the idea of agency. When we have a valid decision maker, a healthcare decision maker appointed by the principal, the patient, then the presumption is that the agent is speaking for the patient. The healthcare decision maker is speaking for the patient. If the provider is unwilling to comply with the healthcare agent's decision, then the provider shall promptly inform the healthcare agent, who will then be responsible for arranging the declarant's transfer to another provider. Most often this will come up in an end-of-life decision, or it may come up in younger situations where someone is looking at an abortion or some other controversial type decision, which some healthcare providers will decline to participate in. But if you do decline to participate in some kind of decision, such as withdrawal of life-sustaining treatment, then you have to promptly inform the healthcare agent of that decision, and then they will be able to arrange for transfer to another provider. Part 3 of the document, everyone has the right to nominate a guardian in writing. One of the reasons you do that is to limit potential controversy, to limit family fights. One of the things that you should keep in mind, though, I rarely see people who are fighting over helping mom with her incontinence products. Most of the fights I see are over the control of money. So if you see a fight going on regarding who's going to be making decisions for mom, there's probably some money back there that people are arguing over. One of the ways that we try to deal with that, and you as a provider might want to talk with families about that. Sometimes we want to separate the money from the healthcare decision-making process. We might do that with a guardianship. We might ask the court to appoint a public conservator or an independent conservator to make the financial decisions and leave the person who really cares about mom or dad in a position to make the healthcare decisions. So separating the money from the healthcare can sometimes diffuse these arguments that are going on. Part 4, the document can be limited in duration. It must be signed in front of 2 witnesses or a notary. We used to require witnesses and a notary, but that's no longer the case. The following cannot be witnesses. The health agent is not a witness. Those who would inherit property upon the patient's death are not good witnesses, and anyone directly involved in the patient's health care cannot be a witness. Now, does that mean if you're a health care provider, you can't be a witness? Absolutely not. It just means you can't be directly involved in the patient's health care. You can't be the one who is giving the IVs, or really the more appropriate analysis, you can't be the one who is trying to counsel the individual regarding which informed decisions to make. The advance directive cannot be required. It cannot be required by the physician, the healthcare facility, or provider. It can be revoked at any time. The best way to revoke it is by doing a new one. And if you just revoke it and you haven't done a new advance directive, then you've left a person in a situation where they're vulnerable, where they may not have a decision maker. And as we started this program, presumably we're dealing with families where there's a dementia situation, and we don't like the idea of having controversy or having no decision maker. Marriage will revoke an agent designation unless the agent becomes this patient's spouse. So if someone has done one of these documents prior to marriage and they've appointed their fiance, for example, and then they marry their fiance, that would not revoke the designation. But if they've appointed someone else, then it might. Divorce will revoke an agent designation. So in those situations, if you have a document where someone is an ex-spouse, that designation is revoked. Now, if there is a subsequent person listed, then that person should become the agent. The statute does not tell us that the document itself is invalid. What it tells us is that agent designation no longer works. Guardianship does not revoke an advance directive. Absent court order, the health agent continues to make health decisions, and the guardian has no power to act. Sometimes we'll have confusion over that because people have not read the law. One of the things that you have to keep in mind is that some of the judges on the bench have been practicing for quite a while, and they still remember the old days of plenary guardianships, and they may not clearly spell out in their order what the guardian can and can't do. Absent a court order specifically providing the health agent does not make decisions, the health agent will continue to be the decision maker, and the guardian has no power to act. What if Lois didn't plan ahead? Are we out of luck? Well, fortunately, Georgia has a default healthcare decision-making statute. Any spouse can make a decision for his or her spouse. Of course, we hope you only have one spouse. If you have more than one spouse, we have some different legal issues going on. But the law does give us a hierarchy on who can make decisions. And not only do we have a statute on healthcare decisions, but we also have a a statute separately giving us a hierarchy, which generally the statute follows the same hierarchy on transfers, admissions, and discharges. Next in line, in the absence or unavailability of a living spouse, any parent, whether an adult or minor, for his or her minor child. Any guardian would be able to make decisions for their ward. Now again, remember, this is in the absence of an appointed health decision maker. A guardian would be able to make decisions for their ward. Any female, regardless of age, in connection with pregnancy or the prevention of pregnancy or childbirth. And then if the agent is unable to consent for himself or herself, the following in order of priority, and this is where you can run into problems if there's not a healthcare decision maker appointed. Any adult child for his or her parents. Now, if we've only got one child, obviously, we don't have a problem, but what does this tell us if we've got 2, 3, or more children? It tells us that you, the poor healthcare provider, are sitting there trying to figure out who do you listen to, because the default statute doesn't tell us which child. It says any adult child. What if Ginger is trying to advocate for the withdrawal of life-sustaining treatment, and Sally, another adult child, comes in and says, I will file a lawsuit, I will go out and get Johnny Cochran or whoever the best lawyer they can think of is, and I will sue you for withdrawing life-sustaining treatment. In that situation, you, the poor healthcare provider, are trying to figure out, what do I do? Who do I listen to? And this can be one reason why we would go to a guardianship, but obviously the best preference would be to have the patient execute an advance directive for health care, appointing someone to speak for them. So under one of the limitations under the default rule, which child decides, or which sibling or which parent decides, you don't know. You're stuck trying to figure out, who do I listen to? That can get us into a guardianship. A guardianship is a court-supervised process. It's a lawsuit. It's a dispute resolution process, and it is a protective device. It does all of these things. It's going to begin with a petition. Can be filed by any interested party. I've had them filed by hospitals. I've had hospitals ask me to file guardianship proceedings when someone appeared to be in a situation where care was futile and we could not find anybody to make healthcare decisions. Typically, the court will appoint a lawyer and an evaluator for the ward. The question before the court is, can the potential ward make or communicate good decisions about his or her personal circumstances? That would include medical care, housing. Where is this patient going to be after they're discharged from your facility? Are they going to go home? Are they going to go to assisted living? Are they going to go to a nursing home? Where are they going to go? If they cannot make or communicate good decisions, then that might be a reason for a guardianship. The conservatorship is part of the same proceeding, but as of July 1st, 2005, in Georgia, we now distinguish the person making medical and housing decisions from the person making financial decisions. We call the individual who makes medical and housing decisions a guardian. We call the person who makes financial decisions a conservator. And the guardianship decision is going to be made by the judge. The judge is looking to determine, first, do we need a guardian? Is this a situation where we have a person who needs help, who needs protection, or is this a situation where someone is trying to play capture the flag with mom or dad, or trying to take over mom or dad's life. The court's going to probably, in most of these contested situations, be determining which person is the better decision maker. And as I said earlier, frequently they're going to be, the court's going to be trying to sort out why people are going after control, and frequently the contested situations will involve money. What if Ginger requests access to Lois's medical records? And you, as the poor provider, are looking at HIPAA, and you're knowledgeable that HIPAA has these civil monetary penalties for violating someone's right to keep their records confidential. So what does the law say about an individual's ability to access information? First of all, a healthcare decision maker is always going to have the ability to get information. HIPAA is a common sense regulation. I was on a panel in Washington, D.C. This past Friday where one of the panelists was Rachel Seeger, who is a senior health privacy officer with the U.S. Department of Health and Human Services. She was telling me and the rest of the audience that HIPAA is a common sense regulation, and the U.S. Department of Health and Human Services has recently prepared a number of consumer videos. Many of them are on their website or they are on YouTube, and they described how HIPAA is supposed to work. One of the ways it's supposed to work is by giving information to the person who's making decisions. Furnishing records, I'm looking now at Georgia law, and remember that under HIPAA, HIPAA sets a floor, but Georgia can go beyond that in terms of health privacy. Whichever one is the more stringent would apply. But HIPAA does not tell us who has the ability to make health decisions. HIPAA just talks about health privacy. Georgia law is what you have to look at to determine who has the ability to make health decisions. Upon written request from a patient or person authorized to have access to a patient's records under an advance directive for health care, the provider having custody or control shall furnish a complete and current copy of that record in accordance with the provisions of this code section. That is consistent with the HIPAA regulations. If you look at the HIPAA regulations are found under Title 45 of the Code of Federal Regulations, Part 164, beginning at 164.500, etc. The regulations indicate that the healthcare provider shall treat the appointed agent as the individual. In other words, the appointed representative has the same power to access health information that the patient would have. That's at Section 164.502G. The exception would be if you have a reasonable basis for believing that abuse is going on. In those situations, you would not be required to provide information. HIPAA, with very limited exceptions, requires a covered entity to disclose protected health information to the patient. An exception might be that psychotherapy notes may be withheld. Obviously, if you could gain access to psychotherapy notes, that might chill the psychotherapist's ability to create full notes. Of course, if you're sitting there with your psychotherapist and they are writing "this person is nuts" in all capital letters, they probably don't want the patient to see that. I'm using that as an extreme example, but we don't want to chill those kinds of analysis. So that would be one place where HIPAA does authorize a provider to withhold. In almost every other situation, though, unless someone's involved in some kind of clinical trial, the patient has an absolute right to get their records. And as I was saying, the personal representative is treated as the individual unless there is suspected abuse. A covered entity may disclose information to identify or notify a personal representative or other person responsible for the individual's care. One of the things that came up, one of the other panelists this past Friday in Washington was Dr. Catalin Roth. She is with George Washington University. She is a geriatrician, and she developed a hypothetical which we talked about, where we had a John Doe that came in, and one of the questions was, can the provider disclose enough information to find the healthcare decision maker? And the answer is yes. HIPAA does allow that. Lois's other children ask questions. A covered entity may disclose limited information to a person involved in the individual's care. The information disclosed must be directly related to that person's involvement with the individual's care. Now, under HIPAA, you will have this minimally necessary standard. You only disclose what is minimally necessary under the circumstances, unless you're disclosing to the patient or to the healthcare decision maker. If you're disclosing information to some family member who is not a decision maker, then your minimally necessary standard would apply. You're only going to tell them what they need to know. For example, if the patient has HIV, they might need to know that precautions are appropriate. Applying HIPAA to the wrong people. HIPAA applies to covered entities and their business associates. It does not apply to families and friends. One of the things that comes up from time to time, covered entities will sometimes get in controversies with families when they try to tell families what they can and can't do because of HIPAA. That's not what the rule says. The rule says that a patient owns their right of privacy, and if the patient chooses to disclose information, they can. That disclosure may take different forms. It may be in the form of photographs showing their presence in a facility. A patient and family members are allowed to take photographs of themselves. The patients are not covered entities. If a provider reasonably determines that disclosure of a record will be detrimental to the physical or mental health of the patient, the provider may refuse to furnish the record. That is a situation where you are going to have to document what's going on. You're going to need to document why you're refusing to provide the record, because the patient is going to have an appeal right. A provider shall not be required to release records unless and until the requesting person has furnished the provider with a signed written authorization. You can demand a signed written authorization before disclosing records. HIPAA does include core elements on what would be in a HIPAA release. One thing to keep in mind, though, HIPAA does not necessarily require that your release be signed. Any release which complies with the core elements of HIPAA would be valid. A patient can give a HIPAA release to anyone, including people who are not involved in making decisions, because the patient owns the right of privacy. So putting all of these pieces together, that's one of the things that you're going to want to do as a health provider. You're going to want to put these pieces together. You're going to want to preserve and protect patient dignity. You're going to want to eliminate controversy by identifying the appropriate decision maker. In some cases, you might suggest that we separate the medical decision-making process from the money. In some cases, it might be appropriate to request a guardianship or that family members consider a guardianship, and you're going to want to follow HIPAA not only in protecting privacy but in releasing information.
Well, thank you, Mr. McGuffey. That was very informative. As everyone knows, we do archive these on our website, again, rosalindcarter.org. And we do have a couple questions for you. Amy asks for advice for working with providers who automatically turn to adult, child, or spouse as kin on record without asking the patient or client.
In my experience, that's probably going to be the result of a bad habit. It may be the result of someone feeling like they're under the gun or pressured in terms of how they use their time. They're going to need to be educated regarding patient dignity. They're going to be, it's going to be necessary to remind them that unless the patient has deferred the decision-making process, unless the patient is incapable of participating in the health decision-making process, then you should still look to them. There's an excellent article that was written by a geriatrician. I believe he's at the University of Pittsburgh. I'm probably going to butcher the pronunciation of his name, but I think it's Karlowish. And he's got an 8 or 9 page article which he published, and it's on the internet, which talks about capacity and the decision-making process. And the capacity is a fluid concept, and you want to allow someone to make as many decisions as they can.
Okay. Well, if you don't mind, Mr. McGuffey, could you send me that, and then anyone that would like to have it, I can forward it on to them.
Sure.
Okay. And then Dion, you may have answered this after Dion had posted, but in the case of multiple siblings, can siblings access the AD that one sibling refuses to produce as proof of their authority to make decisions on behalf of the parent?
Can siblings access an advance directive? There's nothing in the law that gives anyone the ability to hide the ball on these advance directives. If we go back to the, and it's really a self-defeating process. If you try to hide the ball, that was what was going on with Terry Shiva's case. In that case, there was an argument over whether someone was abusing authority. If you're trying to make decisions, you have to, first of all, you have to prove that you've got authority to make those decisions. So I would argue that that advance directive is not a private document. It's not a privileged document, and certainly if a guardianship's filed, you're going to have to produce it to the court.
Yeah, I would kind of think that you'd want to.
Yeah.
Okay, well, that seems to be all the questions right now. Mr. McGuffey, we want to thank you very much for taking time out of your busy schedule. And again, we thank you, and it seems us as providers and even with our loved ones, we have some conversations that we need to do. So again, thank you very much, and everybody stay warm.
Thank you.
Thank you.
Thank you. Please stand by.